Welcome back, everybody, to our studies of the European Convention on Human Rights. In this video, we are continuing talking about some of the basic introductory remarks to this topic, focusing on the contents of the European Convention itself. Now, the convention itself is particularly long, and it has a number of different substantive rights that are established, specifically in Section 2, but then there are also a number of procedural elements that have to be referenced as well. But for the most part, we are going to, in this video, just focus on the substantive rights, just so we can have an idea of the kind of rights which are established by the European Convention. And so as a result of which we have a general understanding of the kind of rights that exist, as well as the kind of rights that also exist in the additional protocols to the European Convention. There are a various number of those as well, and we'll make reference to some of the very important ones that have been passed since the creation of the convention itself. So we're focusing on the rights specifically. It doesn't really make much sense to spend all of our time focusing on every single element, whether that be procedural or not, because we're going to get to the procedure and the enforcement of the ECHR after we have covered the series of rights that we are covering in this series. We're going to look at the convention articles itself and, like I said, the additional protocol. Now, the additional protocols are something that are important, but aren't as important as the convention itself, arguably, given the fact that the protocols aren't a necessary requirement for membership to the Council of Europe. There are some protocols that are far more widely accepted and ratified than others, and so the result here is that fundamentally, where there is unanimity among members of the Council of Europe, it is in the contents of the European Convention. Now, simply put, Section 1 is relating to the various different rights themselves. Now, Section 1 begins with Article 2 of the European Convention. Article 1 simply sets out the obligation that member states have to protect the rights provided for in Section 1. There is a positive obligation on the part of member states to protect the rights which are established in Section 1. Section 1, as mentioned, then goes on to list the various different rights and freedoms that are established by the European Convention, and this is how they are structured. Article 2 refers to the right to life. This is something that we are going to be covering in more detail in future lessons. Starting from the next lesson, we will spend a lot of time talking about the right to life and the various different subsidiary issues and the various different questions that have been asked of the provision in relation to the right to life. So Article 2 relates to the right to life. Article 3, which is also one we're going to spend some time focusing on, is the prohibition on torture and on inhuman treatment. So we're going to focus on what this means, how these two elements are defined, and then how this law is applied to the various different cases. Article 4, which is something that we're not going to reference in too much detail in this series, but maybe we'll go on to when we look in more detail at more advanced topics in the future, is a prohibition of slavery, a prohibition on slavery and on forced labour. Article 5 refers to the right of liberty and security. Article 6, which is one of the most important provisions arguably, is the right to a fair trial. Article 7 refers to the idea that there ought to be no punishment without law. What does that essentially mean? Well, we're talking about there being no arbitrary punishment without due process of law. There has to be a legal justification and a legal process that is gone through in order for an individual to have a legitimate state punishment attached to them. Article 8, which is one that we're also going to focus on, is the right to respect for private and family life. Article 9 refers to freedom of thought, conscience, and religion. Article 10, which is somewhat subsidiary to Article 9, or at least covers similar ideas to Article 9, is the freedom of expression. And then Article 11 is the freedom of assembly and association. We're going to be covering Article 10 and Article 11 as well. We also have the right to marry in Article 12. Article 13 is the right to an effective remedy. Article 14 is the prohibition on discrimination, brackets under the ECHR. So there is a specific caveat attached to Article 14 of the ECHR, but this specific caveat is actually interestingly resolved in one of the protocols that is established subsequent to the ECHR. This is one of the things that's very, very interesting. And a point of reference, should I mention, is that some of the rights under the ECHR proper, under Section 1, are not fully substantive rights in the sense that they protect and they have no exceptions to them. So an example that I'm going to come to here and in future lessons time is that reading just Section 1 of the ECHR itself, reading just the convention rights themselves, and looking at Article 2, we see that there is a right to life. However, one of the major exceptions to the right to life in the convention itself is the exception of the death penalty. The convention does not in and of itself expressly deny the validity of the death penalty. It is only subsequently that the convention has, or at least the court itself, in interpreting the convention in conjunction with a number of different protocols, has been able to outlaw the death penalty under the convention itself. We will get to what this essentially means in future lessons time when we look at the right to life, but it should just be noted that the prohibition on discrimination, as cited here, is quite similar in that this is a limited right in the sense that it is discrimination under the European Convention, but then there has been subsequent protocols that have sought to expand and fill in the gaps where that right has been seen to fall down in certain areas. Article 15 refers to the derogation in times of emergency. Article 16 refers to the restriction on political activity of aliens. And then Article 17 is the prohibition on the abuse of rights. And then Article 18 finally is the prohibition on the use of restrictions on the rights that have been cited. So this is the content of the ECHR. Now, fundamentally, if you wanted to go through every single right and find the extensive discussion, scholarly and jurisprudential discussion on each of them, then the further reading I have cited in the further reading William Schabas's commentaries on the European Convention. Now, a commentary on a convention fundamentally goes through and tackles every single provision and explains it in great detail and is incredibly meticulous. That's why I've put it in the further reading rather than it being required reading for this particular set of lessons. Now, so fundamentally, that is a good place to go. Alternatively, we might in the future do some very advanced lessons on the ECHR where we essentially fill in the gaps of the subjects that we haven't actually looked at here, where I go through the ones that I haven't gone through in this series. Because the focus here is to spend a lot of time on the main and the most important rights, or at least the ones that have the most jurisprudence attached to it, the ones that are the most contentious, have the most different interpretations, and the ones that have the different kinds of questions that are attached to them. So, as mentioned, in addition to the convention itself, we also have a number of protocols. Again, I will not cite all of them. I will cite the ones that are particularly important. So, we have the main articles previously established in terms of the substantive rights. But in addition to this convention, in addition to Section 1 and these substantive rights that are cited, the 18 that have been cited here, there are further protocols that have been issued as a supplementation to the convention itself. Now, there have been a number of them that have been issued in the past. We will make an entire lesson on one of them, specifically on Protocol 14, because that refers a little bit more to some of the procedural elements of the court. And so when we get to looking at the enforcement of the ECHR, we will see that in more detail. Protocol 1 fundamentally was established in 1952, so not long after the creation of the convention itself. Now, the justification for this and the idea of having protocols and additional protocols to conventions is fundamentally the fact that when it comes to negotiating treaties, which is what the European Convention is, there are lots of considerations to be had. The European Convention started out relatively small with a number of European states, mostly Western European states, but there is a lot of negotiation and the deliberation that has to be included in the creation of these treaties. Now, sometimes there is just a failure on the part of delegates to be able to create a treaty that is all-encompassing, and that there are gaps that are left or that there are questions that need to be answered, or that there are issues that are going to be resolved in the future. But essentially the point being that we don't want to have the treaty be held up and the treaty actually not get ratified because we're throwing the baby out with the bathwater, and we are just fundamentally we're gonna let the whole convention fail on the basis of one or two minutiae of points that we can't come to some kind of consensus on. So the point of protocols and having additional protocols to these conventions is that they can provide further protections and substantive law subsequent to the convention itself. So in 1952, for example, we see the establishment of Protocol 1, which adds further rights to the convention rights themselves. It provides the right to property, the right to education, and the right to free elections. So some of the subsidiary rights that weren't necessarily negotiated, or at least they weren't agreed upon in the original drafting of the convention, but that have been agreed upon subsequently with the additional protocol. Protocol 4 is similar. It was established in 1963, and it provided for a number of additional liberty protections. Protocol 6, again, was established in 1983, and establishes the prohibition of the death penalty in times of peace. Now, this is quite interesting. One of the major elements of the convention that really took a long time to get to where we have it today is this fact that in Article 2 of the convention right, which is the right to life, there is this exception to the right to life, which is in cases of death penalties. Now, it took, in fact, 2 additional protocols to fully abolish this particular part of the convention. It took Protocol 6 in 1983 to establish a prohibition of the death penalty in peacetime, in circumstances where we are not in armed conflict, okay? And then we get to Protocol 12, which was established in 2000, which was a general prohibition of discrimination. Remember, I mentioned earlier on that there was that provision within the main section of the convention, the right which essentially suggests that there is a prohibition on discrimination under the ECHR, a very limited right. Well, Protocol 12 takes that right and then fundamentally expands it and suggests that there is a general prohibition on discrimination that ought to exist, and this was established in the year 2000. And then finally, the one I want to mention here is the 2002 protocol, Protocol 13, which not only takes Protocol 6, which is the prohibition of the death penalty in times of peace, but it then goes on to expand that particular provision and suggest that there is a complete prohibition of the death penalty. So Article 2 is now read in conjunction with these 2 protocols to assume that the exception of the death penalty is no longer one that can be heavily relied upon by that of states. Now, one of the things that is something of a drawback and something of a benefit to the protocols is that members of the Council of Europe do not need to have accepted the additional protocols. They have to accept the ECHR in order to be members of the Council of Europe, but they do not have to accept the additional protocols. And there are examples that we see here, the fact that the UK hasn't agreed to all of them, and so they are not obliged or obligated to follow the ones that haven't been ratified. This is a benefit and a weakness at the same time. On the one hand, it is a benefit because what it does is it allows for the creation of a convention that has a number of substantive rights that the entirety of the Council of Europe is willing to accept and apply without needing to force those states to also have to accept and apply all these additional protocols too. It would be nice if we could get every single state to accept all of the additional protocols, but fundamentally, the pragmatics of reality suggest that that's probably not going to happen, owing to a number of different reasons: political, ideological, social, for example, etc., etc. So it means that having this kind of flexibility means that we can still have the enforcement of a number of rights, but that we don't have to, again, like I said, throw the baby out with the bathwater and throw away the convention in its entirety, owing to the fact that we're letting the protocols have the kind of stringent enforcement as that of the convention. So that's one thing that's quite good, but it's also, on the other hand, not the greatest thing, because it means that states do not have to agree to all of the protocols, and a number of these protocols adhere to and apply a number of additional substantive rights that are not necessarily required on the part of states and member states. We'll get to these in more detail as time goes on, however.